good evening and welcome to another program on Law and Order. Every week we have a specialist guest. We have a guest today like that who appeared in this program before. It's his second appearance, and today though we are going to talk to him about a different area of law. My area simply today is what is the role of a criminal defense attorney, and one of the criminal defense attorneys, one of the best criminal defense attorneys in Sri Lanka is my guest, Harshana Ranakara. Harshana, welcome back to the show.
Thank you for having me.
You didn't probably like me saying you're one of the best. I see you giggling.
Just thank you for having me.
Right. Let's start off with the broad question. I know it takes hours to answer this. What would be the basic, if I may to answer, the basic role of a criminal defense attorney, and how does it differ from a prosecutor?
Right. Now, prosecutors as well as us, we are both lawyers, so we pass the same exams. Even if you take a civil attorney, same exams, but we decide to specialize in different areas. Now, the role of a prosecutor will be to conduct cases and to prove beyond reasonable doubt that a person has committed an offense. In the High Court, this function is performed by the Honorable Attorney General, whereas in the lower courts, magistrate courts, generally by the police, unless there's a special reason why there's a lawyer. And in certain instances, even private lawyers are hired to do prosecution for companies. So in certain instances, not only I do defense work, but do prosecuting work as well. However, the role of a defense attorney, in very simple terms, will be to advise your client. And to do that, I know this sounds very basic, but some of us may mostly forget. We have to listen to our client carefully and see what the problem is. And in criminal cases, mostly client comes to you with a serious emotional trauma or emotional disturbance. And even a very educated, learned, informed person could be sometimes behaving a little like a child, not giving you the information you need. So the most important thing is the consultation to identify the issues, the legal issues involved from the emotional run. So once you get that, you advise the client how to handle the situation. If it's a matter that can be settled, and on most occasions, the ego prevents people from settling a dispute. So then you have to wait for the second or third consultation to tell them, look here, would it be cheaper for you to go for this kind of a settlement? But if they insist on fighting the case, then we of course go ahead in the court and do whatever is necessary to defend that person. But at all times, the client must be given the options. He must be completely informed the legal situation before the client takes a decision as to what they want to do.
Right. Now, being a criminal lawyer for so many years, when a person comes, there's a saying, I'll explain this a little, that you should not lie to your doctor and your lawyer. It is you who will be in trouble. Right? So, when a person who has done a crime comes to you, especially a serious crime like rape or murder, in your experience, do you tell them that you have to tell the truth, or do you see they are at a point that they are not telling the truth and then try to say it, or how does it work? How do you extract the truth before you defend them?
Now this is actually, you won't believe, Shanaka, this has been one of the most common questions I get faced even when I just walk to a party or just to the shops. Right? So I'm glad that you asked. I would like to explain it this way.
Yes.
Now, when a man comes and tells you something, or a woman comes and tells you something, I don't ask tell me the truth. Because extracting the truth is a matter for the courthouse. My duty is to assist the court with the facts and the client's case so they can determine the truth. The problem with how media, especially social media, reports certain things, the moment someone is arrested, the headlines are as if the man has been convicted and put behind bars, which will give you a nice opening for the next question on bail. Right? But the reality is, nobody knows the truth. It has to be decided according to evidence. So what I do is, I think my brothers do the same, that is, tell me what happened. Now, when they tell me what happened, I simply will present those things to the courthouse. But if I find some of the facts which they are presenting are nothing but ridiculous, I will tell them so. And especially if I see a defense, if they say, sir, I did it. I killed him because he tried to kill me. So we have the defense of self-defense. Well, Then they might say, sir, he died, but I was not planning to kill him. He was insulting my wife. And then I just punched him. I never thought to kill him. So then we handle the case accordingly. So the common idea that the lawyers will twist the words and lie to court, get their client out, is not true. Not at least with all lawyers. Because whenever something wrong has gone, we advise the client on the available defense.
Right.
And then you may not get convicted for murder, but for a less offense. And the truth, remember, is not what the papers report and not what goes on TV, but what is decided in the courthouse.
Probably except for the program Law and Order.
Yeah, of course, yeah.
Right.
That I'll give it to.
But take a scenario like this. This I have seen in movies, this I have seen in real life, this I have seen in so many areas. The client doesn't tell you the full story. Like you said, you don't have a duty. Don't you have a duty to tell them to tell the full story? No, no such duty.
Basically, I have to tell them to tell the truth.
Truth. Okay.
Right? But if I know, strictly speaking, they tell me, sir, I killed him, then I have to decline the case if he still want to be defended. But many people would like to plead guilty for less offense. For moral reasons, you would have to decline. For moral reasons.
But is there a legal duty for you to defend him?
Of course, there is a legal duty. That's
why you have the choice.
I have the choice. Any lawyer has a choice. Now, for an example, I don't defend child abuse. I don't defend domestic violence when women are harmed. Those two I don't do. That's my choice.
Yes.
Right?
Okay. Now, what if somebody does not tell the whole truth and you go for advise him or her the available options, then you go for trial. Criminal case, maybe rape, maybe murder. Halfway through, you discover facts through prosecution which basically crashes your case. At that point, what is the role of the criminal defense attorney? Can you just leave the case saying, because I have seen that happening even in very high profile cases?
You shouldn't.
You shouldn't?
You should. There's
what should be the duty?
Well, basically, in the case of a high court, there's no way we are going to be surprised in any way. Because with the indictment, all the witness statements are given. Non-summary proceedings are given. So for those reasons, you cannot be surprised in a high court.
Right.
So therefore, you know before you start the trial what you are getting yourself into. But however, if you feel your client has done something like trying to bribe a police officer during the trial or something completely unethical, then you can cite those reasons and move out. You can move out because they have tried to interfere with the course of justice in some way. In those instances, you can leave. On the other instances, as long as you are collecting instructions from your client, you must continue to appear.
Even if unless a material that is, like you said, transpires.
Well, if something like that transpires, that is not the merits of the case. No. While the case was going on, say for an example, he had tried to bribe a judge. And if you know that, what if the judge just says, oh, this man, Mr. Nanayakara, called my friend and told me that to help him with the case. Now, on those instances, I am completely entitled to leave.
Okay. When you, what are the instances in criminal law? Most of the major offences, when you will say lose the trial, get convicted, which you did not expect, a punishment that you did not expect, which you did not advise your client. So you gave him ABC option, but X came as a result, which is a different thing. Then you go for appeal. Or what do you do at such point?
I mean, I can't talk on behalf of all the criminal defense lawyers, but in my case, when I gave option ABC, generally one of them happens. Generally one of them happens. Yes. But the problem with the client is that they are not willing to give. When I say plead guilty, for an example, instead of the 20 years, if you plead now, I can get you 3 and go away. Now, many clients do not want that. They want me to fight the case. But when the what is up to the neck, they say, sir, can we get that? Too late now. So, these things do happen. Sorry, your question again, I'm sorry.
Yeah, that was basically the answer.
Yeah.
you gave the answer in a different way. Okay, let's go to this other area which we touched upon earlier, bail. Now, lots of people have this, common people, of course,
who are not lawyers.
So they have the opinion that when you there are serious criminals who are arrested after much investigation, and then they go to court and they get bail, and they come up, people think, sometimes some of the press thinks that this fellow has gone scot-free. He shouldn't have. He should have been straight away punished and put in. So explain to me the concept of bail and where does it apply and where does it not apply?
Again, it is the public perception of these concepts that is causing heartache to the public.
Right.
And which I'm sure media plays a good role in sensationalizing and putting on as headlines, except for Law and Order.
Yes.
Right? So, okay. Now, bail is a situation where a man is not convicted of an offense. he has been arrested under suspicion. So when a man or a woman is arrested under suspicion, you cannot curtail his liberty permanently because he has not been found guilty.
Right.
Just because the papers put a headline saying rapist arrested, school teacher who molested this person arrested, doesn't make that person a guilty person. No. You must have a trial first. Now, bail is where under section 14 of the Bail Act, the magistrate will consider whether there are any impediments to grant him bail. Otherwise, they will be granted bail to face trial. Now, getting bail and going home doesn't mean he's been cleared of all charges. It is just been decided him being out is not going to cause an obstruction to justice. In fact, bail means the state custody, the custody of the state has been handed over to two other people who are duty bound to bring him to court. Now, prison, on the other hand, is after trial, after evidence being led, after conviction, that is prison. So, and bail will depend because in certain offences. Biggest problem is, I won't blame the public for this, they have a general distrust towards the judicial system and sometimes the Attorney General. They say, oh, for this case they got bail, why not for this one? Oh, for this bail was refused, why not? Each case is different. And the judicial officers will act on the merits of it. So therefore, the public getting all disheartened, oh, he get bail, so now everything is over. They get that feeling simply because charges take 7 years to come. So they feel that he got scot-free.
For 7 years, yes.
But that is not the case. And by the time a conviction comes about 10 years later, people don't even remember for what reason that fellow got convicted. So then where's the deterrent effect? The deterrent effect is not there. So that is the concept of bail and being imprisoned.
So if I may to go a little bit away from this and come to the concept we were debating and toying every day, justice delayed issue, as much as justice rushed is justice buried, as you said. In order even for people, in order for criminal justice system to work properly, the fast tracking, if I may use that term, of the process of trial of a criminal case is
essential.
Otherwise the deterrent effect is not there.
Well, people must remember for what this person is getting convicted, right? And I know some people who get convicted for 2 years because the entire village does not know what he is getting convicted for. He will inform the village he is going for overseas employment and go off. You see, because people don't remember. So I think if a case can be started and concluded within 2 years' time, probably people will remember. The deterrent effect will be there.
Right. Now, there's another misconception people have about remand and prison. Can you explain what is the difference between these two? Is it the same?
As I said earlier, prison is where you are being sent for 2 years, 3 years, 4 years, 5 years, after the trial, after evidence being led, after he has been found guilty by a judicial authority.
Right.
Bail is a temporary situation after arrest. If released on bail, if the court is of the view he might interfere with just course of the justice, if he has threatened witnesses, he might interfere with evidence, or there will be a public disquiet, or he might commit more offences while on bail, then bail can be refused. Say for an example, if one has 5 cases of murder, he's arrested for another murder, the judge might refuse bail because he's been shown he has a propensity to commit more offences while out on bail. So if those things are not there, he must be granted bail. So you cannot find fault with the judges or police or anybody, depending on the case.
Now, I believe, if I may stand corrected, that criminal defence attorney's role play in court, as far as courthouse is concerned, in the magistrate courts, in the high courts, and the appellate courts, and the Supreme Court later. Now, can you just briefly explain to our viewers who doesn't know, what are the different roles you all play in these 4 forums?
Well, the magistrate court and the high court are both original jurisdiction criminal. So that means we tend to defend clients from charges. This is on top of the regular advising and guiding them as to the right course of action.
Right.
Then at the Court of Appeal, then the defence lawyer's role will be on an appeal. And Supreme Court, of course, is another appeal. So in those instances, we appeal saying that the lower court's order is either wrong in law or fact. And we are trying to point it out. No witnesses are being led there. So in all these instances, the rule number one for a defense attorney is to efficiently assist the court, honestly assist the court, honestly and efficiently advise your client as to his rights. And while doing that, keep to your morals and ethical standards of not just a lawyer, as an average human being. Because I always see, they say, oh, he's a good lawyer, oh, he's a good doctor. I tell my friends, don't use those terms. First, be a good person. Then I'm willing to call you a good lawyer. So your basic morals and decency must be there. And you must efficiently perform your role in advising clients. Problem with most of us, including me, is that when the clients are stressed out, they don't understand what we're saying.
Right.
It'll take some time for them to understand. That's why the initial consultations, we are more like counseling. We are more like psychiatric counselors mostly.
Right.
We have to have a lot of patience with clients.
Right. So, coming back to one of my earlier questions, because people think that when they do crimes, that the lawyer at any cost have to get them out if he pays the lawyer. There is no such duty on a defense attorney?
No such duty, but in fairness, I do not know who these other lawyers are. But some of them will defend even when they know the man come with a bloodstained knife, they will still defend.
But isn't that his right to do that legally?
Yes. That is a law. It's a constitutionally guaranteed right, because everybody is presumed innocent until proven guilty. That's a constitutional right. Every lawyer has the right to defend anybody, because just because of an allegation being made by the public doesn't mean he has done it. So there's nothing wrong with any criminal defense attorney even defend the worst case of crime which they perceive as a wrong man. Now the Kondayas case is the best example for you to know how people got everything wrong. How many people did they arrest? So if the lawyers did not appear for the previous innocent fellows, they'll be inside. How many times, it only the fifth or sixth person they finally got the right guy. So what if the lawyers didn't argue for the first four? They would be inside. So therefore, I will ask everybody not to go by the media as to a person's guilt. So let the lawyers do their job.
Right. Then comes this theory about privileged communication which lawyer has with a client. Right? When a client comes and tells the story. Can you tell me the boundaries of this privileged communication which you have as a right as a lawyer?
Well, I think there are certain decided cases on this. I am not going to talk on them, or neither am I aware of all those things. But basically, if the client is planning to commit a crime and communicating that to you, I don't think any lawyer should be keeping quiet about it.
Right.
They should simply completely inform.
Yes.
But at all other times, what the client says, you are entitled to keep it for free unless there's a court order to another way. Now, a recent case.
Sorry, may I interrupt you? Can a court order lift the veil of privileged communication?
That depends. That I really cannot answer right now unless I really look into it.
Yes.
It's very rare.
Very rare.
Very rare that it's very rare that a judge would order that, because I do not know how that operates, to be honest.
Right.
But all I know is that when a client, recently there was a case who approached me and said his wife was murdered. It's a very well-known case. It went on the paper, so I will not mention names.
Right.
When he was explaining to me, he said, I figured out that it is he who has done it.
Right.
I figured it out, and it was obvious, it was on the papers thereafter.
Yeah.
But he came to me 3 days after, about 1 day after the incident. His wife has filed a domestic violence case against him. The moment I felt he has done it, I said, right, the first thing you should do now is go to the police and assist them with the investigation, and I send him off. That's what a lawyer should do. When you know the man has committed a crime and come to you, but that's what a lawyer should do, but I do not know how many are doing it.
Okay. What is the role of lawyer, a criminal defense attorney once again, as this is our topic, in assisting clients in the police and the CID and other government authorities? Do you have to accompany? Are there times that you cannot accompany them to police, or are there times you can't participate
depending
in
on the establishment.
Okay.
Now, for an example, we can always write to the Attorney General and go make representations. Those are places where the client is not allowed to go in, so we have to go on behalf of the client. At police station, we can go to surrender accused parties, or we can simply go for some other representation. At the CID, we have to write letters and inform law, then go with them. So, depending on the place, yes, we can go with them, yes, we can represent them, and people should not fear asking for lawyers' help if the police are asking them questions. The police sometimes tend to tell you you don't need a lawyer. We are just going to ask you only 1 or 2 questions. So in those situations, you can always call for a lawyer. There's a right for lawyers to represent clients at police stations and in most other establishments.
Yeah. I have seen in other countries, the moment you're arrested, they say they won't talk a word saying, I want my lawyer. But we don't see that here. Do we have that by law, the right for the citizens?
Yes, we do have a right, but how many know that they have to exercise it?
Right. Okay. Coming back to another point about defending clients. Now, we'll say, take an example where nobody wants to defend a particular person who has committed a crime. We say we come to a situation like that. What happens to that person's rights of defense?
Well, I think in serious crimes, the state can assign you a counsel. So he will appear for the client. And I tell the public as well as my brother lawyers, do not refuse clients unless there's a valid reason, a very valid reason. But lawyers have a right to refuse. But in serious case, in High Court, they will assign you a counsel from legal aid to represent his case.
Right. So the worst criminal will not go without
everybody will be defended in the High Court.
In the High Court.
In the magistrate court, it may be differ because in magistrate courts, people are entitled themselves to defend themselves.
Yeah. Sometimes there are practical examples where when you go to the police station or similar authority, the authorities tend to say that there is no need of a lawyer or a representation of a lawyer at this point is of no use for your complaint or whatever. You probably would have had clients coming back and telling you this. What does a client, a citizen, do in such a point? Whether it is the police or the CID or some other authority.
Firstly, I would like to tell the citizens,
yes,
do not go to take legal advice from police. Go to a lawyer.
Very well said.
Because police cannot give us legal advice.
Yeah.
The same way you don't go to a mason and ask him to build a chair for you, do you? But the public seems to be listening to the police more. So that's their plight.
Yes.
I would say, whether you need a lawyer or not, go and ask a lawyer.
Right. In Sri Lankan criminal justice system, what would you like changed as far as the law is concerned?
Laws, I mean, I don't know whether I'm even qualified
Improved, yes.
I don't know whether I'm qualified to answer such a question of a profession which is over 200 years old now.
Right.
So, but let me put it this way. I'd like to see that people get justice a little faster than this. I would like when people come to court, their case are heard and finished. A little bit.
Is it a lacuna in law somewhere that this justice is getting delayed because it comes up in every discussion I have? Is it a lacuna of law? Is it a lacuna of the administrative system? There are no facilities, there is no funding. Which one is the problem? Or both?
The first one is that the resources of the state sector. I mean, if you look at a courthouse, a High Court judge is also a human being, not a machine.
Yeah.
How many trials is he to hear every day?
Yeah.
And when defense lawyers come and move for dates in various innovative ways, despite the, how can they say no? So therefore, yes, there's administrative issue. I think there should be more resources, more courthouses. Honorable Attorney General should be equipped with more staff, more state-of-the-art material, whatever necessary. But there's another important thing, attitude. That is also very important.
Attitude of who?
All actors involved in the justice process, from start to finish, that they are providing a service, that they are trying to do a service to the public.
That has to change.
Attitude has to change.
Harshan Nanakar, thank you very much for those very insightful thoughts on a very vibrant, wide topic like defense attorney's role, which we cannot complete obviously in one program. Thank you for joining and
thank you for having me.
Thoughts.
Thank you.
That's Law and Order for you today. We'll join you next week at the same time with another program on Law and Order. In the meantime, if you want to watch our previous shows, you can go to our site www.channeli.lk and go to the drop down menu, pick Law and Order, and you can watch our previous shows all over again. Have a nice weekend, good night, and I'll see you next time.